Eleanor Fox. I am very pleased to present this short video to you on competitive neutrality for the OECD Roundtable in its Global Forum on Competition. And now I am going to share my slides with you. I am going to concentrate on state restraints on competition. My thesis is that state and local government restraints and hybrid public and private restraints are the biggest offenses to the principle of competitive neutrality. One may even query whether the concept which we are talking about today should really be about leveling the playing field, which might suggest fairness to non-state rivals, and whether rather it should be about removing unreasonable state and local restraints that harm markets and consumers. And indeed, the OECD recommendation of 2021 on competitive neutrality stresses and certainly includes removing unreasonable state and local restraints that harm markets and consumers. This is my outline. I'll say a few words about the problem of state restraints, and then I will turn to two different aspects. One is state restraints in internal markets and how the competition authorities may try to attack them. And the second is regional cross-border restraints. And my suggestion that this is really the new frontier where the competition authorities should be paying a lot of attention and collaborating more on the identification and, of course, the attempt to eliminate unreasonable state restraints cross-border. And then a conclusion on what I think competition authorities can do. The problem of state restraints is a very severe one. And I love this quote, which is from Tim Uris some years ago, talking about state restraints as compared with private restraints. And although competition law is so often confined even to private restraints, these quotes from Tim Uris show why the other side of the coin is state restraints. He has this wonderful analogy: protecting competition by focusing solely on private restraints is like trying to stop the water flow at a fork in a stream by blocking only one channel. And he goes on, regulatory success in attacking private restraints increases the efforts that firms will devote to seeking public restraints. Indeed, rational firms are likely to prefer public restraints. Public restraints can be far more effective at restraining competition. And of course, I said I will stress on the hybrid public and private restraints as a special problem. And I worry a lot that vested interests get protections that often fall between the cracks of public and private restraints. And to some extent, of course, that implies vested interests simply working against the public interest. And of course, we are also talking about good faith regulation that goes just too far. Internal market. This is public restraints within a nation or jurisdiction. There are so many examples of very serious, way overbroad, harmful public restraints. Much attention has been given to advocacy, rightly, because the competition agencies are looking around to see what are the bad restraints and advocating with agencies and the public on how to remove them. Because advocacy is so well discussed, I'm going to turn to one other aspect which I think is underexplored. even though a great number of countries have adopted this methodology. And that is, there are a number of competition laws that give the competition authorities power to enforce against state and local restraints. Deborah Healy and I wrote an article on this, which I have cited here, when the state harms competition. I am going to turn in a minute to just two examples as examples of what jurisdictions can do when their law gives them the authority to attack unreasonable public restraints. The example from Lithuania is here. It's Article 4 of the Lithuanian competition law. And I've quoted from the law to show you that this is really about competitive neutrality. Entities of public administration shall be prohibited from adopting legal acts or other decisions which grant privileges to or discriminate against any individual undertakings, which may give rise to differences in the conditions of competition for undertakings competing in the relevant market. And there is an exception where the law requires otherwise. The agency can require the state body to abolish the measure. Lithuania recently published its annual report of 2020 and gives some wonderful examples of what that is the competition authority of Lithuania, wonderful examples of what it has done within the past year or two. It has, for example, brought proceedings against the Transport Safety Administration, which violated the competition law by not giving a competitive procedure before extending 42 intercity bus route contracts. This is akin to procurement without process. It often is about vested interests simply getting the privilege in favor of getting their contracts renewed without competition, causing bus prices to go up and often hurting the very poor. I like the second one because the authority also fined the Ministry of Justice for setting minimum fees for notaries. The authority has power to opine on draft laws. And last year, it examined 482 draft laws. It is invited to make suggestions. It made suggestions to make it more competitive in about half of them, and about 77% of its suggestions were adopted. A second, and the only other big example I am going to raise right now, is Peru and Indicopy, which is an agency which includes the competition. It also includes intellectual property, and it also includes an arm which tears down bureaucratic barriers. And this quote is from Indicopy itself. It is from the authority filing a note with the OECD on taxi rides. Indicopy exercises a regulatory role, applying an ex post control on administrative regulations of public institutions such as municipalities and ministries. It is invited to declare municipal ordinances, agreements, resolutions as bureaucratic barriers to competition. And once its resolutions are approved, the public entity must not impose those bureaucratic barriers. Indicopy has stricken down thousands of bureaucratic barriers. It has been recognized by the ICN World Bank competition every year for success stories for its work in striking bureaucratic barriers. There is so much more work that is done. This is the tip of the iceberg. As I said, I'm not spending time on other advocacy for internal market. I'm turning now to cross-border and regional. And I am suggesting that this is a big issue and problem that requires lots of attention. There are so many cross-border restraints, and apparently many are not detected. Researchers find that the goods and services do not flow over neighboring borders the way you would expect under conditions of competition. Something is holding them up. It is either private barriers or public barriers, and probably both. The restraints are raising barriers to the market, facilitating cartels, protecting monopolies, and rigging procurement. The European Union, of course, is the great example of law that integrates trade and competition in the internal market, and integrates it also with state-owned enterprises and enterprises that get privileges. The EU has a great framework that integrates trade, meaning the state restraints, competition, usually the private restraints. This is a great framework. The framework has actually been adopted in so many words in a number of other common markets, but nowhere else are trade, internal market, state restraints, and competition restraints integrated. Regional integration is a real priority, especially for developing countries, and it cannot happen well without attacking the cross-border public and private restraints. Africa is a really good example. Many of the countries in Africa do not have natural trade routes with each other, the mark of colonialism, which made the trade routes from the country to the colonizer deeply embedded. There are obviously many barriers, cross-border barriers, public and private, probably both. The research group at the University of Johannesburg called CRED, once formerly led by Simon Roberts and now led by Thando Vilakazi, has done enormous work showing that there are serious problems that need attention in basics: sugar, maize, soybeans, cement. Flows of trade that cannot be explained except by agreements, cartels, or state intervention, or both. Africa cannot realize its dream of integration without eliminating the cross-border restraints. Now, a word of conclusion. What can competition authorities do? Competition authorities are very active in this area and are doing many very, very good things. Much great advocacy. In addition to advocacy, as I have laid out, possible law reform to empower the authority to challenge the public restraints, put procurement, competition, and corruption under one roof. Regional needs very serious attention, higher level consciousness of cross-border restraints, and more collaboration of the authorities to identify the restraints as well as to remove them. Trade and competition needs to be under one roof. This is the issue of tomorrow. So thank you very much. A pleasure to talk to you today.